Hello, my name is Steve Wu. I'm a partner in the Silicon Valley, California law firm of Cook, Cobric & Wu, LLP. Today I'm going to be talking about what happens when you get sued. I'm talking about a lawsuit that you may have received by way of papers that are delivered to you personally or at your office. One of the documents might be called a complaint, and one of the documents might be called a summons. I'm sure you've heard about lawsuits. I'm sure that you know that starts the lawsuit process rolling, but you may not be sure about what happens next and what you need to do to protect your rights when you get sued. When a plaintiff starts a lawsuit, it's done by filing a complaint with the court. That court could either be a state court or a federal court. Our law firm represents both plaintiffs and defendants in both state and federal courts in California or in other parts of the country. When the plaintiff files a complaint, that complaint has to be delivered to you in this case or to whoever the defendant is. And sometimes it's brought personally to that defendant or left with someone at the office. That has started the process of the lawsuit going. You then have a certain amount of time to respond to that complaint by filing your own documents. What happens if you don't do that? The danger is that the plaintiff can get what is called a default judgment against you, where the plaintiff wins without you even being able to battle to defend yourself. It's really, really important that you hire an attorney to help you defend yourself. Otherwise, the plaintiff can get a judgment against you and start trying to take your assets to pay for that judgment if you don't do something to defend yourself. And if you have been sued, you do need a lawyer. So let's talk about the process of what you can expect if you have been sued. If you want to defend yourself, this is the process. In response to the complaint, you can file a document that either says to the court, here's how I'm answering the complaint. I deny that I'm liable to the plaintiff for what the plaintiff claims. That's essentially what you're saying in a document called an answer. Or you can file a document that points out the legal deficiencies of what the plaintiff said in the plaintiff's complaint. And there are other documents that you can file along those lines to try to get the case dismissed at a very early stage. If that has not succeeded in getting the case dismissed at an early stage, then you begin the process of gathering evidence. In federal court, the plaintiff and the defendant have to exchange information by rule. But in either case, state or federal court, there's going to start a process where the parties start gathering evidence to anticipate what's going to happen at trial. They want to collect the critical information that they need to prove their case at trial. They do that in a number of ways. One way is for the parties to send each other written questions that have to be answered under oath. Those questions are called interrogatories. When a party asks you to answer interrogatories, you have a certain amount of time to respond, and you have to answer those questions under oath. Another way that evidence can be gathered is to send the other side requests for paper documents or for electronically stored information. This is often the heart and soul of the evidence gathering process, because you can get the writings that provide the evidence in your case to help defend you or to pursue your claims against the other side. After these initial exchanges of information, the parties may have what are then called depositions. A deposition is where you or another witness is asked questions under oath in person by an attorney, and the questions and answers are recorded by a court reporter. So the attorney asks a question, the witness answers the question, and the court reporter types down everything. Some of the depositions are recorded on videotape, in fact. So these three processes are the main processes by which evidence is exchanged. Written questions called interrogatories, requests for documents or for electronically stored information, and depositions. After the depositions are over, the parties may then file what are called motions for summary judgment. A motion for summary judgment is a document filed with the court saying your side deserves to win the case right away without having to go to trial. And one reason might be because, again, the other side's position is legally deficient, or it may be because after all of the evidence gathering that's passed back and forth, there just isn't enough evidence to support the other side's case. Or the evidence is so overwhelming that no reasonable jury could find for the other side. Sometimes both parties file motions for summary judgment. These motions are resolved, and they may end up disposing of the case. And if you're the defendant, that means you may get out of the case at that point. But regardless, if the motions for summary judgment are not granted, then the case will go to trial. The trial date is usually somewhere between 1 year and 18 months after the case is originally filed. Sometimes it could go longer depending on the judge and the caseload. Once the trial date is set, then the parties begin the procedures by which they're preparing for the trial presentation. And a trial is, as you've seen, I'm sure you've seen, a process by which witnesses come to testify about what they've seen or experienced or understand about the case. And there are also perhaps expert witnesses who will testify as to their opinions concerning some special aspect of the case. And after all the witnesses have testified, there are arguments by the counsel, and then a judge or jury gets to decide the case. After the verdict in the case, then there may be an opportunity for both sides to file what are called post-trial motions, which are documents filed with the court after the trial is over, asking for the judge to, for example, grant a new trial or to grant a ruling in favor of the party that lost. After the post-trial motions, then there's an opportunity for appeals to the Court of Appeals in the federal court, or the California Court of Appeal in the case of state court, and then on to the Supreme Court, either in the federal Supreme Court or the California Supreme Court. There is a procedure by which cases in the California Supreme Court can be reviewed by the United States Supreme Court. Once the appeals are exhausted, then the case is over in terms of fighting the merits of the case, and there may be a process, if the plaintiff wins, to try to collect on any judgment that the plaintiff has. But you as a defendant hopefully will have prevailed at some point along the way, and either the plaintiff has not appealed the decision or the case is resolved in your favor. At any point along the way, there is an opportunity to settle the case. Some cases are settled early, and some cases aren't settled until an appeal is pending. In any case, a good lawyer should be able to counsel you as to the strengths and weaknesses of your case and advise you as to whether it's worth fighting the case either on legal points or on the facts, and help you decide whether or not you want to settle the case. And a good lawyer should also be able to counsel you as to whether it makes sense to go to trial in your case. So with that, I've laid out the basic procedures for resolving a lawsuit in case you get sued in court, so that you're armed with the information to help you understand what your options are, and you have an understanding as to what you need to do to help defend yourself. In any case, if you've been sued, you do need a lawyer. Our law firm stands ready to assist you in the process of helping to resolve any lawsuits in state or federal court in which you've been sued. Thank you for your time, and I look forward to helping you.